Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We are here this afternoon for the submission of two cases. The first one is Doe versus Western Dubuque Community Schools. And it looks like the parties are ready. Mr. Pundt, and I believe it's Mr. Richard Pundt, correct? Thank you.
If it may please the court, as the Chief Justice indicated, my name is Richard Pundt, and I'm one of the attorneys representing the plaintiffs in this case, the Doe parties, against Western Dubuque Community School District. First of all, I want to thank the court for accepting this case for what we believe are four critical issues that need definition in the state of Iowa. The first is regarding an anonymous pleading, a Doe pleading. The second is qualified immunity under 674A. And the third relates to negligence as it would fit under qualified immunity. And the last would be breach of fiduciary duty, also fitting under possibly fitting under qualified immunity. In this particular case, we believe that there is precedent within Iowa for us to proceed as a Doe pleading. There are multiple reasons for that as we set out in our brief. The first, of course, is the electronic filing. And since the electronic filing, we are compelled to bring an anonymous pleading when it involves a minor. The reason the parents need to be anonymous as well is if the parent's identity were disclosed, everyone would know who the minor is. And that holds true of the address as well. Of the address, if we were to plead the address of the adults, they would know the identity of the minor.
Trial?
However, in the trial, I believe the court would then have the option of instructing the jury relative to the identity of the minor. But in the entire trial, we would all have to be mindful of the electronic filing and the fact that the minor's identity needs to be protected. So I think admonitions by the district court in the case of the trial would be to the jury not to disclose, or anyone else.
For sex abuse and things like that, we protect the child as much as possible. What allegations are in this case that rise to that level of that extra protection we take for child welfare cases or sex abuse cases of the victim? How does that extend beyond that?
Extends because of what might result in retribution against the minor.
Almost every lawsuit I've ever seen, there's a fear of retribution by the plaintiff.
Retribution by the superintendent of schools?
Our concern was retribution by other students because this was a student-to-student assault that happened. We had genuine concern that the identity of this student needed to be protected. In the facts of this case, also, the student who we represent had a brain injury, and as a consequence, she had psychological issues that...
Woods class in front of a bunch of kids, unlike, for example, a sex abuse case that normally happens in the dark, quiet area of a home with no other witnesses. Aren't you trying to compare this to something that's much, much different?
We're not really trying to compare it to that, but we're trying to have the court afford a protection to anyone that's a minor. And we're reading the statute, the electronic filing, to encompass any minor.
It makes the minor confidential, but not generally the parents. And I realize there's some, maybe there's some contradiction there, but the general rule is the business in courts is done in public. If you're allowed to name a defendant publicly, kind of the trade-off is you come forward publicly. I like the chief, I struggle to see how this case is so sensitive that it would, more sensitive than the usual case.
For two reasons. One, because of the minor's circumstance and what happened to the minor and the possible retribution by other students. In fact, this particular minor has had some issues with retribution by other students since. But I think more importantly, we're bound by the electronic filing. There's nothing in the electronic filing that says in an incident like this that we can differentiate it from any other case where there's a minor. In other words, we feel we are duty bound to bring the action as we did.
Then what's the argument for the DOE designation? Let's assume that rule is not interpreted as you're requesting us to interpret it.
Question, I think we have the answer to that. I think the practice in Iowa has been to protect a minor even without the electronic rules, and for a long, long time, as long as I can remember, we have brought a case that involved the minor with the name of Doe.
This case from now on be John Doe and Jane Doe?
The two people involved in a divorce case are not minors, or their children.
Here, I mean, in that case, there's minors, and there's a lot of shenanigans that go on in divorces, and in probably a majority of the divorces, there are some shenanigans that the parents would probably rather not have the world know. Once that case is done, it becomes public. So why should those parents of children who are being protected be treated any differently? We're outing them.
I think, to answer the question and to follow up with what you're saying, that's why Doe is important, whether it's a divorce case or a case like here, to protect the identity of that minor. And coming back to your questions, what other precedent other than electronic filing? We have a string of Iowa cases, we've cited a number of them in our briefs, that already have used Doe to protect identities. One of the cases we mentioned, I think it's a John and James Doe, because of an HIV issue, that had a statute. Here we had a statute as well. We're analogizing that. But beyond all that, we do feel there's precedent in Iowa from Iowa cases where Doe has been used. We even have 3 other cases pending now that all use Doe because of minor. And this is the first instance we've ever had that challenged. And one of the reasons we feel that's unusual for it to be challenged is from what I just said. There is precedent. There are a number of cases in Iowa where Doe has been used. And in addition to that, you might look at the cases involving minors in juvenile criminal cases or divorce cases where initials are used. And even the defendant in their brief says, well, that's acceptable. Why initials would be any more acceptable than Doe, while Doe has been used for years, escapes us. In other words, both sides are at least saying to this court, protection of minors are necessary.
And by having the names out there, the child's name, in this case, are you alleging any time in this case that the child's name has not been protected, or that the court is ordering you to release the child's name and make it public?
No, we're not saying that there's been a violation of it. We're just saying that we need this court to provide a standard. There isn't a standard now other than what I'm saying, that we can call upon past precedent where Doe has been used, or we can call upon the electronic filing requirement. What we're trying to do and hoping to do, accomplish at least in that regard, is a definitive action by this court. In Riniker, which is cited by both the defendant as well as us, there's a portion that the defendant goes to great length to cite Riniker, where in Riniker, the Court of Appeals says, we aren't going to take it upon ourselves to make that decision. We'll leave it to the Supreme Court or the legislature. And that's what the Court of Appeals has given us to present.
In the rule 16602, between the name of the minor and the identity of the minor. I mean, so the rule says that the name of the minor has to be kept confidential, but you're seeming to say additional information not involving the minor should also be redacted to the extent it reveals the minor's identity, and those seem a little bit different.
That's correct. We are saying that, and I think that presents the quandary, why we're here before this court.
To some extent, that kind of pointless. I mean, you said yourself the child was struck in a class in front of other students. If the lawsuit's alleged and we put Doe, and the people who are interested in the case are already going to know, I mean, who the child is.
And maybe that's why she's had reprisals. But the point is,
It's already happening.
anything further that might occur. But in any event, we need a guidance. I think all attorneys are going to face the same thing we are. We need guidance here. And Riniker talks about a balancing act, and so does the John Doe case, the HIV case. They talk about a balancing act. And that balancing act is all we've had to rely upon now, other than past practices, where we've used Doe for plaintiffs in civil actions, and others have used initials, for example, in juvenile cases involving divorce or juvenile cases that involve criminal activity. So we really are here partly to have this court give us, all of us, guidance on how and when we can use DOE. We're here because we believe we followed the proper procedure and we're mandated because of the electronic rules to do so.
Interested in some of those other issues as well. First of all, I guess I question whether you've pled up to the standards that are required a claim against either the superintendent or the chair of the school board. It strikes to me that what you are describing is a situation that happened within a particular school, and how the superintendent or chair would have been personally involved in this situation or responsible for the harms you allege. It's not clear to me from reading your petition.
We've answered that in our second brief point and our reply brief. Before we filed the lawsuit, we examined what the Western Dubuque Community School District posted. In other words, what did they recognize as the laws they must file? They had various links. Now, even though they took the links down, we captured what they had and we put it in links, and we've cited those links in our brief. And in those links, they specifically state that they are obligated, and they cite the Iowa law. For example, the anti-bullying one we cite, and at the end of that, if you look at the link, they actually cite the Iowa statute and federal statutes as well as cases. The same thing is true in regard to, the care of a minor if an injury occurs. So what we did, and that's paragraph 35, by the way, of our pleading, what we did is we said that these were in place at the time this injury occurred. The district court misread. We said they were in place, and then we cite specifically 8.
Those were in place, and even if they created some sort of legal obligation, it strikes me reading the petition, there's nothing really connecting the chair or the superintendent to the failure of this people at the school to meet these obligations if they were obligations.
Your point, Your Honor, and what my answer is this. If you'll look at our pleading, we name the principal, the superintendent, and the president of the school board in their official capacity only to bring in Western Community School District. So that if they, for example, the president of the school board acted in order to pass or promulgate these various rules, that's why they're in there. But we're not suing them personally. We're suing them in their official capacity on behalf of Western Dubuque Community School District. I hope that answers your question, but that's what we're doing here.
To the district and leave them out of it.
When we started looking at how they promulgated these, we noticed that they said that some of these are the obligation of the president of the school board, others are the obligation of the superintendent, and others the obligation of the principal. That's why we did it in their official capacity. I agree, it would have been cleaner if we could have just said Western Dubuque Community School District, but once we started looking how they did this, we felt we were forced to bring them in their official capacity.
Fiduciary duty claim specifically, and how you've pleaded that or alleged a duty?
Did allege that the fiduciary duty primarily came about after she was injured. The school undertook the obligation of a parent in parentis where they had control over the student. Neither the student or the parent had any control at that point. And even though the school district may not have a fiduciary duty in general, but once that happens, once the injury happens, they have a duty and they are duty bound to fulfill their obligations for the care, physical care of that child. And we've enumerated within the pleadings how that was the case, where she was taken from the classroom to the principal's office and left there alone, wasn't given any medical care. The parents were not called. Ambulance was not called. She was given a couple ibuprofen. She had a concussion, passed out. Nothing was done. That's where we believe the fiduciary duty begins.
Duty, or is that a different kind of duty, like duty of care, reasonable care?
Both.
Stott's case as saying well, there might be a fiduciary duty between a teacher and students in a given class. You haven't sued the teacher of this particular Woods class, but other than that, other school officials don't generally owe a fiduciary duty to a student. Is that, am I misreading the case or overreading the case?
I think there's another case that I'd like to draw the court's, I don't have the site right in front of me, but it's the Mitchell case that came out of Cedar Rapids some time ago. Okay, court, yeah, and in that case, I think the court was even reaching beyond school premises and saying that the court had, as we read it, a fiduciary duty, and that's what we're saying here,
Case, though, I think.
the negligence case. But what we're saying is that's analogous to this, because the school district did have a fiduciary duty. Once that injury occurred, they then became more than just the school. They had a legal obligation, the fiduciary obligation, for the welfare of that child.
Thank you. We'll get you back on the next round.
Thank you.
May it please the court, counsel. The parties are here before you today due to the district court's grant of defendant's motion to dismiss. We're here for two primary issues. One, the plaintiffs brought a John and Jane Doe petition, which is not permitted under Iowa law. And two, plaintiffs failed to meet the heightened pleading requirement under Iowa Code 670.4a. Regarding the John and Jane Doe petition, we're dealing with primarily two rules. One is 1.201, which requires every claim to be prosecuted in the name of the real party in interest, and 1.302, which requires an original notice to contain the name of the parties. You'll notice from plaintiff's briefing that he acknowledges our rules do not permit a John and Jane Doe petition.
You just might have to ask for, I mean, someone has to challenge it, but someone can try, right? And yeah. All right, and so the hearing addressed that very issue, am I correct? Did you object to that immediately?
Motion to dismiss, Justice.
I didn't know at what stage it was. I couldn't remember. Thank you.
Would you agree that the federal rules are sort of similar to the Iowa rules in terms of the rules that you cited, that 10A is similar to 1.201?
I don't know the answer to that. I know a lot of the briefing that plaintiffs cited to was the fair notice of pleading, which really what we're dealing with here is the heightened pleading requirement of 670.4a. So I know that the case law that they really cited to doesn't really apply here. I don't know if that answers your question or not.
To the names of the parents, there are many federal cases that permit parents to go as parent Doe. And the federal rules strike me as pretty similar to Iowa's rules. So I'm just wondering if there's a reason why you think we would interpret Iowa's rules as saying that you can't do that at all.
They filed our motion to dismiss based on Iowa law, which really, I think the main case that is considered is the Reniker case, where the court said, hey, this might be a good idea to have a balancing test, but the rules don't allow it. And we're not going to create it, and we're going to leave it to the legislature of the Iowa Supreme Court. And that was more than 20 years ago, and there's been no change to our rules. So I think in Iowa, that's the precedent that we're sitting in and that we have to comply with.
Different sort of injury if this were sexual assault and not, assault with a weapon, I guess, or whatever you want to call this welded block of wood. Would that change your view at all? Is there any sort of injury that a minor could have that would permit a parent to go by parent Doe in a case?
I know that, Justice, and the reason why is the only case that I could really see that the court considered and permitted a Doe pleading was regarding an HIV diagnosis, and the court there said it's because, hey, by statute, we allow that to be confidential. I don't know off the top of my head if sexual abuse or something like that, if there's a specific statute that would answer my question of if there is, then I'd say yes. If not, I'd say no.
That, you convinced the district court to agree with you. Were they given the option of repleading with using the actual name, using the actual parent names? Wouldn't that maybe make some sense here?
So really, we filed a motion to dismiss on 2 basis points, which really our rule says that we have to file both of them together. I understand that the rule for the real party in interest generally requires a reasonable notice for them to amend. But here the court ruled on both basis points and therefore dismissed the case, and that's where we were at. I think it wouldn't be in the interest of judicial economy to dismiss on the one, Jane Doe petition, allow them to amend, then come back for the other. But the answer to your question is no, the court did not do that.
I'm guessing the former trial judges among my colleagues know the answer, but there is a protected information sheet that's filed. Do you get access to that
I don't know that I do, Judge.
when they file? Because that obviously discloses identities, addresses, all that information.
There's an allegation here, at least an argument here, that that the school knew who this student was and who these parents are. Is there any dispute from your side about that, that the identity of the plaintiffs are known or unknown?
I don't think so. He pled enough facts that, hey, we have a pretty good idea of who it was. I think the dispute really comes in, well, who is the parent or guardian or adoptive parent or whoever that is bringing the case? Because that's when we have to analyze, okay, is there standing, is there jurisdiction, and issues like that. And I think that's the issue that's created if they're allowed to proceed anonymously, because a lot of times we have to raise that, at the preliminary stages, otherwise it's deemed waived. And I think that's why, by and large, our rules say, hey, you can keep the name of the student confidential with initials, but hey, you have to plead the parent just so we can analyze, well, is it a parent, it's an adoptive parent, is it a guardian, or is it some random person, just so we can analyze that issue. Did that answer your question? Yeah. Okay.
Struggling to apply the qualified immunity statute to common law claims. It seems like it's not a good fit in my mind. So tell me why it should apply to common law claims, and how would you plead a negligence claim, like clearly established law for negligence?
Iowa Code 670 applies to all torts by definition. I understand, hey, it's a little different. A lot of times we deal with qualified immunity in the context of like police conduct and stuff like that. But I do think it's a good idea to.
Point, you said it applies to all torts by definition. I guess what is the statutory text that indicates that?
I call it off the top of my head, but I believe in the introductory paragraph to 670, it says applies to all torts against a municipality.
I guess I'm looking at the language that says it deals with right, privileges, or immunities secured by law.
And I thought there was something in there that said all torts. I could be mistaken.
Are you referring to the liability? Under 670.2, liability is imposed for all torts. Is that what you're referring to? Okay.
I mean, I haven't settled the point, and you may be right. You may not be that it applies to negligence. What about? It strikes me maybe on the fiduciary duty where it's a more cutting edge question whether school officials even owe a fiduciary duty, that there might be some obligation to plead that explain how the law is clearly established, or plead that it's clearly established. Is it possible, to maybe we should draw a distinction between torts that actually are established in our law and those that are less established?
In my opinion, Justice, I would say no. Maybe that's because I'm on the defense side. But, you look at like the facts here, and really, hey, we're at the motion to dismiss stage. We take the petition as true. And so you kind of look at, okay, what have they pled? And one is plaintiff minor student was in shop's class and she was hit with a board by another student. They plead there was no prior incident between the two students. And they also plead that there was a teacher in there supervising. The question is, what is so clearly established that every public official, so every school administrator, every teacher should know, hey, this is a violation. This is what I should have done here.
on the ground. I mean, in negligence cases, and I'll preface it by saying, I'm sure you're familiar with how federal courts apply this clearly established standard under federal qualified immunity questions. And you have these cases that draw minute distinctions, you know, one of the most famous being like a dog bit a guy who was laying on the ground, and they held there was no qualified immunity because the most relevant case, a dog bit a guy while he was sitting on the ground, and they thought that was constitutionally different. So in a negligence case where you have all these very, very small variations in the facts, how do you plead the law as clearly established if you're a plaintiff?
Based on the existing case law, you know, that's what clear.
So like if we did the federal standard here, you know, this might have been a 2 foot long piece of wood, but we only have a case involving a 3 foot long piece of wood. So we're going to say there's no negligence because we don't have a specific case on point. You know, there's 25 kids in the classroom in this other case. There were only 20 in this case, and that makes a difference. So you don't get to go and have your case tried. Is that how you're advocating this should be interpreted?
You know, a lot of qualified immunity cases are like excessive force and stuff like that. Okay, a lot of times those hinge on, you know, minute facts, such as, hey, we all know that you can't use excessive force, but hey, if the suspect is fleeing, you know, no longer posing a threat, okay, you can't use deadly force then, or something like that. That's kind of the purpose of qualified immunity, though. You know, all of the definitions are, listen, these are public officials. They shouldn't be held liable for bad guesses in gray areas. You know,
Problem which I have is, you know, we're familiar, you're familiar with the law of qualified immunity in federal law. It's not a pleading requirement. It's a substantive requirement. So you move for summary judgment and you say the law wasn't clearly established, and then you argue about the law. And as Justice McDonald and you've been pointing out, sometimes there are these pretty small distinctions. The legislature, in their wisdom in Iowa, has decided to make it a pleading requirement. So now it sort of suggests you have to plead law, which is, you know, kind of explain how the law is clearly established or not, which sounds like something you would do in a brief and not in a petition. What's your view on that?
the only thing I can cite you to, Justice, is the general case law for qualified immunity is, the courts have always emphasized, mostly the federal courts, saying this is immunity from suit. It's not immunity just from damages. You know, and allowing a case to proceed defeats the purpose of the immunity. So really, I mean, for whatever reason, our legislature said, hey, we want this a pleading requirement. They must have thought having public entities in these gray areas where the law is not clearly established, having them go through discovery, depositions, and ultimately a motion for summary judgment, they must have come to the decision, the policy reason that, no, because it's qualified immunity and it should be decided at the earliest stage, this is what we want to do.
The facts in paragraphs 17 and 18 of the petition referring to an apparent past history of issues with a student that assaulted the minor plaintiff. Was that enough to put, for negligence purposes, to put the school district on notice?
The plaintiff student had prior issues with the district?
The kid who was, the middle school student who assaulted the minor plaintiff, paragraph 17 refers to that he, I'm assuming it's a boy, but maybe not, that student had some, quote, some apparent past history of issues, including disciplinary matters that were known to certain school personnel. Next paragraph, it said time and place, the prior history of issues involved the other student who struck minor Doe was known to the officials at Drexler Middle School. So I guess their thought is that that kid shouldn't have been in the classroom.
It depends. You know, I think I'd really look at it is based on the facts of the student. You know, I don't know what the prior discipline issues are. You know, we have to just go based off their petition because we're at the motion to dismiss stage. But, you know, if it's, hey, the student was tardy or, you know, some miscellaneous issues, really the question here is there notice to the school district that we're comfortable saying, hey, you had a duty in this circumstance, especially when there was no interaction between these two students? You know, what are we supposed to do? Just separate the two students or that student from everybody? That's the question.
They needed more facts to flesh that out to meet the heightened pleading standard. Okay.
To what Justice McDonald, I think, was starting to talk about the statute itself. So as you point out, 670.2 says that a municipality is liable for every tort of its employees. 670.4A is a qualified immunity protection. And under subsection 3, it says a plaintiff who brings a claim under this chapter alleging a violation of the law. Is a tort necessarily a violation of the law?
Assume their count is negligence, so I'd say yes, Justice.
So is it enough to say that we know what the elements of negligence are? And so, I mean, that seems to be a very specific thing. And again, to Justice McDonald's point, I think qualified immunity arises in federal context, at least. It's a violation of the Constitution. So excessive force is a violation of a very specific constitutional provision or a statute. And so that makes more sense to say that that's a violation of the law, but a tort, to just say a general negligence common law tort, doesn't seem to be quite the same thing.
Answer your question. I see my time's up. I don't think that simply pleading, hey, negligence and the elements of negligence would satisfy the qualified immunity. If you did that and that satisfied it, then really qualified immunity doesn't exist. I mean, you just plead that there was a duty, there was a breach, and there was causation, and that survives qualified immunity. I think it would essentially gut the qualified immunity when it's really intended to only hold public officials liable for clearly established law.
What relevance, if any, does it have that the statute was only passed after the Godfrey decision, creating a constitutional tort, which is similar to the federal law? Now that we've issued Burnett and held that there is no constitutional tort, it seems like the purpose of the statute, if I'm reading it fairly, I think that's probably a fair read, is gone now. I mean, the legislature was perfectly fine with allowing tort claims to be asserted against municipalities and municipal officers, and there are a whole bunch of exemptions, et cetera. So it just seems to me that the reason the statute came into being is no longer in being, and maybe we should just set it aside. I mean, I understand you're here to defend the statute, but
I rely on it.
that's not an unfair reading, right, of what happened and what motivated the passage of this qualified immunity statute.
The sequence of Godfrey and Burnett and then the passing of this statute, you know, I read the statute as written, and I think it still applies, Justice. Thank you.
Thank you. Back to Mr. Pundt.
May it please the court. I wanted to just recap here. Just make a note here, if I may. There were several questions that were just posing counsel. Justice Mansfield talked about the basis for 670.4A may no longer exist. Justice Oxley said, is a tort a violation of the statute? Justice Waterman talked about the student's past conduct. And I believe it was Justice Mansfield who talked about certain keys and the law, whether it needs to be pled from the legislature. I believe each one of those questions is important, and that's why we're here. That statute that the legislature passed created this conundrum. That's why we needed your guidance, and we are happy that you're taking this, because we feel that we did exactly what the statute required. We were mindful of the statute, and we did exactly what it required. We did detailed pleadings. What we did is we followed the statute. We pled with particularity. We showed that the law was clearly established by citing their own policies and procedures, paragraph 35, and we enumerated 8 subsections where they actually cite the law. And so we're saying, do we need to go beyond that, and do we need to actually cite, for example, the code section that deals with, the code section that deals with bullying is Iowa Code section, as Western Dubuque cited it, Iowa Code section 232.67, 232A, 235A. Do we need to do that? The statute doesn't say, and we don't have any prior guidance from anybody. So in each of the questions that were asked, it focuses on why we're here. One of the big reasons we're here. We did not, when we did those pleadings, have guidance. So when we drafted this, we felt we did exactly what the statute required. We drafted with particularity. We showed that there were cases, or pardon, not cases, but law in place based upon their own policies that we cited in paragraph 35. So that's one of the things why we're here. We're glad that you're hearing this, because it brings me to another point that I made in my argument, and it's made in the briefs of both parties, particularly the brief of the defendant, where they cite the Renneker case, and they have I think it's page 14 of their brief. They have a long dissertation lifted from Renneker, and in that case, a court of appeals said, we aren't going to make that decision on Doe, for example. We need to have the Supreme Court or the legislature make the decision. So our problem is really what the legislature did or didn't do. They didn't give us any guidance. And so our poor clients are on the horns of a dilemma. We're trying to plead this as exactly as we can, with particularity, with detail, and to show that the law was established at the time based upon what Western Dubuque Community School District already recognized. So we did everything we could. So we're asking you, did we need to do more? Did we need to actually say this is a code section that applies or that is a code section that applies? The statute that the legislature passed isn't clear. And the Court of Appeals decision in Renneker is not clear. And that's also true in regard to Doe.
In your resistance to the motion to dismiss, did you ask in the alternative for the opportunity to amend your petition? Okay. Now are you asking if we did?
That's required, absolutely. But we need the guidance here.
That opportunity, even though you didn't ask for it?
Offer the opportunity.
If the court were to conclude that this could be done, the Doe pleading, on a case-by-case basis, using some sort of balancing test, as Justice McDermott noted, there are a lot of federal circuit court cases on this point. They have different kinds of tests. Is there one in particular that you think is better or most appropriate?
I would say the only guiding element that I have there are the electronic rules. And the electronic rules are saying, and by the way, opposing counsel did get a copy of our Form 17.10, so they knew who Doe was. And there were emails between the school district and our clients and opposing counsel. They knew the names of our clients. That was not a mystery. So coming back to your question, I think what may be a solution here would be for a party to bring a Doe pleading. Simultaneous to that, an application to the court. Not only do we have to fill out the forms for the confidentiality forms, the 17.18, 110, I believe, or we have to fill those forms out. So while we're doing that, maybe we should file an application that the party be anonymous. So I think that would be consistent with the rule that exists, the new electronic rules. Did that answer your question?
Of Doe versus Western Dubuque Community Schools is hereby submitted, and we'll have a brief pause while the next case of Ruiz versus State, counsel can approach.